teams that made the tournament.
But it was a down year for them.
We'll see if that's not a trend. Because
I mean, there's no. Okay, I'm going to call the Tuesday, March 24th, 2026 meeting of the Oxford Board of Zoning Appeals to order at this time. Would you please call the roll?
Mr. Creech,
Here.
Mr. Cheffin,
Here.
Mr. Russo.
Present. Okay. Also note for the record that Councilor Kennard and Zach Moore from the city are also present as well. Okay, first item on the agenda is approval of the January 27, 2026 meetings of the regular meeting of the Oxford BZA. You have the minutes. Any modifications, any concerns? Is there a motion to approve the minutes?
Okay.
Moved.
Seconded.
It's been seconded. All in favor indicate by saying aye.
Aye.
Opposed, abstentions, the minutes have been passed. Old business is the next item on the agenda. Case BZA 2025-0336 East High Street, the administrative appeal to section 1137.10, replacement of changeable marquee signs with electronic message boards. Jack Grove was the appellant for Weissman Enterprises Holding, representing Weissman Enterprises Holding. The hearing was held, testimony was provided to the board deliberated, and at its previous meeting, voted to deny the administrative appeal made by the staff at that time. We have a written decision prepared to codify that vote. I will read it for the record, do we know if the appellant is making a?
No, I spoke with Mr. Grove, and he indicated that he was aware that the BZA would be memorializing the oral decision that it made, so there was no reason for him to be here.
Okay, well, I will read the decision, the written decision, and then we'll get a sense from the commission as to whether it represents their decision from the last meeting. This is case number BZA 2025-8-03. The matter of Weissman Enterprise Holdings was the appellant regarding the decision denying appellant's administrative appeal of the city's staff decision denying a sign permit. Procedural history was such. Appellant Weissman Enterprise Holdings filed an administrative appeal with this board pursuant to the City of Oxford codified ordinances, C 1129.11 of the Oxford Code. Appellant appeals the city's staff decision denying an administrative request for the city staff to issue a sign permit for, quote, replacement signage on marquee, unquote, on the property located at 36 East High Street, Oxford, Ohio. The property is the location of a business known as Brick Street, a bar and entertainment venue located in the city's Uptown Historical District. Before this matter was heard, appellant obtained a certificate of appropriateness, a COA, with conditions from the Historic and Architectural Preservation Commission, HPAC, on November 12, 2025, for the installation of an LED sign. The LED sign could not be installed until the city issued a sign permit and the COA. This matter came before the board for the hearing on November 25th, 2026. The board heard from witnesses testifying on behalf of the city and the appellant. Testimony lasted almost 3 hours, and exhibits A through J were introduced, including a 106-page transcript of the HPAC hearing where the certificate of appropriateness was approved and reports submitted by the appellant. Submitted on behalf of Dr. Joss Keeley, an associate professor at the University of Cincinnati School of Architecture and Interior Design, and Thomas W. Breedenstein, AICP. Following the close of the hearing, the board, by motion, second, and unanimously voted to adjourn into private deliberations as authorized pursuant to the authority of TBC Westlake versus Hamilton County Board of Revision. Deliberations were suspended because the board needed time to review the entire record. The board resumed deliberations on January 27, 2026. Following deliberations, the board announced its decision subject to the issuance of a formal written opinion. The board informed that the parties that it would deny the appeal, but strongly encouraged the appellant to request a variance, since the variance process was the proper procedure under the city code to obtain the relief that they sought. Before reaching its decision, the board reviewed the entire record of the evidence presented at the hearing, including testimony, documents, reports, the HAPC transcript, and the appellant's summation. The decision. The board denies the appellant's appeal for the following reasons. The board concludes that installation of the LED sign is not maintenance or repair under the City Code 1137.10, Section C. In our view, installing a new LED sign is replacing the existing sign. There is no dispute that the existing sign on the property is a non-conforming sign, and a legal non-conforming sign loses the legal designation if the sign is replaced. See City Code 1137.10, Sections B, subsection 1. There can be no question that an LED sign is not the same as a manual copy marquee sign that currently is on the property. Next, the board must consider City Code 1151.03, Section B, which states that no signs are permitted other than those permitted in this code. As to this point, the board agrees with the city staff that an LED sign is direct illumination signage and therefore not allowed in the Uptown zoning district. See City Code 1151.05, Section C, subsection B1. While the board has determined it is compelled under existing Oxford Code to deny the appeal, the board makes the following observations and comments. The board believes this appeal should have been pursued as a variance request under City Code 1139.01, Section A, subsection B, and Section C, which states, A, purpose, a variance permits variation from the strict interpretation of this code so that no specific provision prevents development of a specific site that would otherwise not be possible and that would satisfy the general intent of the code. Use variances are prohibited. Section B, variance requirement. Each variance shall be granted according to the provisions of this chapter. Section C, effects of variance. A variance shall be valid only for the specific use, site, location, and provision for which it granted, and changes to the use, site that change the facts upon which it is granted shall be strictly interpreted. Here, appellant seeks to have the board ignore a strict reading of the city code. Based on the plain reading of the city code, the only process the board may rely on when a party appears before it requesting relief that ignores existing city code requirements is through a variance. For this reason, the board encourages appellant to seek a variance. In rendering this decision, the board is mindful and acknowledges city staff admission that the city code pertaining to sign regulation is outdated and likely vulnerable to legal challenge. Indeed, the city is in the process of rewriting the city zoning code to address this concern and other concerns unrelated to this matter. For the foregoing reasons, the appellant's administrative appeal is denied by unanimous vote taken on January 27, 2026. Appellant is, however, strongly encouraged to exhaust its administrative remedies and seek a variance with a request for conditions, including the conditions approved by the HAPC. Okay. We have read that into the record. I'm going to ask if there's any questions, concerns. Does this written decision reflect essentially our decision made at the last meeting?
I believe that it does.
My concern is on page 3, the last paragraph. It asks the law director, why do we need that last paragraph about our concern about it being outdated? How's that relevant to our decision?
Because it's part of the record. It's up to you. You're the body. I'm only the legal advisor, but it's up to the record. It's part of the record, and it's a.
Which last paragraph, Steve?
It starts with the rendering the decision as board is mindful acknowledges. There's 2 sentences in there. And basically they say that we think this code is outdated and maybe shouldn't, I don't know, the implication is we shouldn't be following the code. I just don't know why that language is there.
Well, staff informed us that their their sense was that it was outdated, that there was changes needed, that council was indeed undertaking that. That was made clearly in the record. I think we were all operating on that and incorporated that into
Yeah, I
our
think that's fine,
consideration.
that's in the record.
consideration.
I just don't think it needs to be included on the decision, because it's got nothing to do with our decision, that the council, that city council may be amending the code. That's great, it might help this guy down the road, but it's got nothing to do with our decision.
It informs the public of
Yeah,
part of the deliberative process of what the body did.
Yeah. Yeah, it was part of our deliberative process. It came up numerous times, both in the public hearing as well in our deliberations. I have no problem
And
leaving
then,
it
and
in.
last thing is, the last sentence, appellant is however strongly encouraged to exhaust its administrative remedies. What do you mean by that? What additional remedies? His only remedy now is go to court. Is that what you mean?
No, he's got, the decision clearly says he's got an opportunity to go and get a variance.
Was that's the administrative remedy
Right.
you're talking about? Oh, okay.
Right.
Right.
And we made that very clear
Okay.
in the presentation.
So I have-
Okay, so at this point, I'm going to ask for a formal vote that the written decision reflects the meaning and intent and the spirit of our voted denial of the appeal. All in favor?
Aye.
Aye.
Opposed? None? Abstentions? I will sign this. Okay, so, Chris, in the open meeting by a vote of, I guess it's just the three of us that are here, right?
Yes.
Okay, this decision, although the appeal denial was actually a 5-0 vote in the
But the
previous
body's
meeting. So this,
adopting it.
this is, okay. This date is the 24th.
And I would also point out that while and you didn't read the footnotes, they are somewhat relevant because the appellant had complained about the timing of a number of things, but the body reflects in the record why those delays occurred.
I ask this be submitted into the record as written as well as read. So, okay. I've signed it. How many copies do we need signed?
Another one, just two.
Okay.
Two.
Okay. We have no other business before the board. I'll take a motion to adjourn.
Move.
It's been moved.
Seconded.
All in favor indicate by saying aye.
Aye.
Opposed? Abstentions? We are adjourned. Thank you. Okay. Thank you, thank you, thank you.
All right.
You want to
Thanks.
keep
Sorry
a
about
copy
the
for
reading.
yourself?
Absolutely.
I signed that one.
That's good enough.
Good night, John.
The recording's off. Oh, just sign that one.